primary purpose of the Indian Penal Code and the CRPC is to make sure that the state is not destabilized. Hate speech is not episodic. Hate speech is not instantaneous. It's very discursive. It's a narrative that is built. So I remember when I was growing up, people sometimes still in sort of perfectly amicable situations would turn around and say कि मगर आप लोग तो पाकिस्तान को support करते हैं cricket match में, right? Or somebody else would say कि भाई appeasement बहुत होता है. But the problem is that it's systemic. If they never said to me what they said to me, auto drivers will come to Jamia and there'll be no problem in renting to Muslims and there'll be no problem in employing Muslims. So how do you deal with the systemic nature of this? The Indian Penal Code and the CRPC, the Code of Criminal Procedure, they're both colonial legislations. And the victim is not at the center of these laws. The accused is also not at the center of these laws. The state is the center, right? So the primary purpose of the Indian Penal Code and the CRPC is to make sure that the state is not destabilized, right? So everything is looked upon from the perspective of stability, law and order, and public order. The victim is not so important. The accused is not important at all, right? Now, coming from this perspective, all the offenses around speech, for instance, are bracketed in different chapters, right? There's a chapter on tranquility, crimes against public tranquility. It's got nothing to do with discrimination. It's got nothing to do with marginalization. These are crimes of law and order. And that's where 153A comes in. Now, one important thing to see here is that the law is looking at two communities as equals, right? I provoke you, I say something that you don't like, you get provoked and you react. And that's how law and order problems are created. So here the two communities are equals. And there's a very fine book by a professor called Niti Nair. It's called Herd Sentiments. And she's traced the development of case law around these particular provisions of the Indian Penal Code. And it's embedded in equality of communities, pre-partition in colonial days. One community, one sensitive community would react to something that the other had said. So remember this, and this is a problem now. This is how we look at the problem of hate speech and hate crime. But the social and political equation has completely changed. The communities are not equals anymore. But everything is looked upon from the perspective whether this speech will cause a law and order problem or not. So for instance, when West Bengal banned the Kerala story, the producers came to the Supreme Court and their primary argument was, this has not caused any law and order problem. So why are you banning it? And the Supreme Court said, yes, you're right. It's not caused any law and order problems, except some skirmishes here, some skirmishes there. But that can be contained by the state if the state wants to do it. So therefore, they've removed the ban. But there's jurisprudence in other countries, particularly in the European Court of Human Rights, which is looking at the problem of hate speech from a completely different perspective. And law and order has nothing to do with it. Right? They're saying that this is not a problem of offensive speech. This is not a problem of hurting sentiments. This is a problem of discrimination. This is a problem whereby you're pushing certain people outside of social, political, economic spaces such that they are marginalized, such that they suddenly find that the ground beneath their feet is gone, that they're not social equals, that they're not political equals, that they have no livelihood options. That is the problem of hate speech. So the idea of discrimination is at the center of hate speech. It has got nothing to do with law and order. Now, the other problem with this is, when it was directly about law and order, when it was directly about violence, it was easy to criminalize it. आपने कुछ ऐसी बात कही जिस पे किसी और गुस्सा आया, you could be arrested for inciting violence, for provoking people. But that's not how discrimination works, right? Hate speech is not episodic. Hate speech is not instantaneous. It's very discursive. It's a narrative that is built. So I remember when I was growing up, people sometimes still in sort of perfectly amicable situations would turn around and say कि मगर आप लोग तो पाकिस्तान को support करते हैं cricket match में, right? Or somebody else would say कि भाई appeasement बहुत होता है. Now these are very casual sentences. They just sort of they said off the cuff, but they repeated and they build a narrative and they build a discourse. And what this government is doing is only building on these stray thoughts and stray dialogues, right? When they now paint Muslims as imposters, as marauders, predators of land and livelihood and of Hindu women. It's the same discourse, right? That's carrying on. So then how do you criminalize it? If it's discursive, if it's not episodic, if it's a whole narrative, right? कंचन गुप्ता भी वही बात कहते हैं, सुदर्शन टीवी पे वही बात होती है, but the way they say it is sometimes in the form of dog whistles, sometimes much more direct, and sometimes actually inciting violence. But you can't criminalize each of these dialogues, and that is the problem of law in dealing with hate speech. We don't know how to deal with it because we don't know where to set the threshold. But this is one part of it. The other part is, if you look at another chapter in the Indian Penal Code, which talks about sedition, right? That is also a speech problem. Now, there the problem is not framed as something between a dialogue between equals. There the state is superior. And you as citizen are not supposed to insult or humiliate or bring about disaffection against the state. So the state is very much superior. If you think about badtamizi in our social context, how does badtamizi work? Badtamizi is always something that a social inferior does to his social superior, right? अगर आप अपने बड़े से बदतमीजी कीजिएगा, that's badtamizi. If the elder person has been railing and ranting at you, that's not badtamizi. आप नीचे निकल के रिक्शे वाले को डांटिए, that's not badtamizi. अगर वो जवाब दे दे, that is badtamizi. That social idea is now being transplanted in understanding the law of sedition, or the law of defamation, or the law of terrorism itself. So badtamizi is anything that a dissenter says to the ruling establishment, or anything that challenges the ideas of establishment, right? Now this is the problem. When it comes to challenging the ideas of the ruling establishment, the threshold has been made very, very low. You can say anything and they'd say this is a terrorist offense. But when we talk about hate speech, we're still thinking about where to set that threshold, right? But if we set that threshold very low, even in the context of hate speech, it will come back to bite us because that threshold is already very, very low when it comes to dissenting speech. And again, there is an explanation in law. And that explanation is this, that oftentimes both these debates are looked upon as being complementary. They're both looked upon as, pushing the idea of free speech. But hate speech is not complementary to free speech. Hate speech is the exact opposite of free speech, because free speech comes from an impulsive, democratic space, right? It comes from a democratic impulse, and it's about inclusion of more and more people in the political social space. Hate speech is anti-democratic. Hate speech comes from that position of bullying and pillorying for power, and basically pushing anyone who's marginalized outside of political and social spaces. So according to me, these are the complete opposites of each other, though optically they may appear to be very similar, right? And they've been recognized as such in law, especially and again in European jurisprudence. But I'll cite you Supreme Court case law, which says that hate speech pushes the idea of discrimination, and therefore it's always inflected with power. Hate speech is always inflected with social power and with political power, and therefore hate speech is always majoritarian speech, right? It's always directed at minorities. A minority cannot indulge in hate speech against the majority, because a majoritarian idea cannot easily be pushed outside of social political spaces. At best, it will be a corrective. And this was said in this very important case called Pravasi Bhalai Sangathan versus the Union of India. It's a case from 2014. And it only repeats what the Law Commission of India, the 267th report, says. And they in turn borrow from the European Court of Human Rights and some of the newest UN resolutions that have come out that have recognized three things basically: hate speech, anti-minority, majoritarian problem. Hate speech is not an offensive hurt sentiments problem, but it is a problem of discrimination. And third of all, we need to find a threshold to define hate speech, because it's systemic and it's cumulative. It accumulates over time and it causes material harm. It causes constitutional harm. We'll have to recognize that there is no parity of power in social life, and there's no parity of power in political life. And even though we're all supposedly equal citizens, there's actually no parity of power, even in law, right? That's a very difficult realization to come to. And again, I think in terms of where we're at discursively today in our political lives, that's a very, very difficult acknowledgement to make. So unless we make that acknowledgement, how are we going to bring about laws that recognize that this is only a problem that targets minorities? It's a majoritarian flexing of muscles. That requires a very mature degree of political sense, of political debate. I don't see that happening now. So now if we come out with some kind of law that defines hate speech or frames hate speech, it is going to be very half-hearted. It's going to be very immature. And it will not recognize that it's only a majoritarian thing that happens. It will treat everyone as equal. Dissent then would be treated as hate speech. Anything that is a pushback towards establishment or towards establishment ideas would be treated as hate speech. But what I would suggest is that we try other experiments where once you recognize that there is material harm as a consequence of speech or as a consequence of identity-based crimes, then we need a declaration from the courts that these are constitutional harms. These are not just material harms, but these are constitutional harms because they're attacking the very basis of fundamental rights, right? Now, once that happens, there are other ways to do it other than asking for its criminalization or asking for bans or regulations. What are those ways? We have remedies in civil law. We have remedies in tort law, for instance. There's a whole branch of law that is being developed outside of India called constitutional tort. So every time there's a constitutional harm that occurs, we should go to court against the state and say that you've contributed to the incidence of constitutional tort and now compensate us, compensate the community. And that is something that we need to think about and possibly try and develop in jurisprudence. South Africa has tried this for apartheid, recompensation, etc. And I think that might be an answer. That might be so it's more ambiguous. It's not asking for regulation. It's not asking for criminalization. But it's striking where it matters. It's asking for money and for compensation. See, my own worst example of constitutional harm is sitting at a very nice lunch, and then somebody turning to me and saying, "Magar Mughal जो थे उन्होंने हिंदुओं के psyche को destroy किया है," and implying that I'm responsible for it. That's the degree of violence that I've personally encountered. As an example, somebody else has been lynched, right? Somebody else has been refused rentals or property sales. Somebody else has not got a job because of their identity. So even within the community, because of class and caste and gender and all kinds of things, that particular material harm is not common. But the problem is that what is said to me is connected to an auto guy saying that I will not go into Jamia. I will not take you to Jamia. Which is also connected to delivery boys not coming to Jamia, or somebody not being able to find a house outside of Ghaffar Manzil. These are all connected, but the material harm is of a very, very different order. How do you compress everything into the same material constitutional harm and say, find me a threshold? But the problem is that it's systemic. If they never said to me what they said to me, auto drivers will come to Jamia, and there'll be no problem in renting to Muslims, and there'll be no problem in employing Muslims. So how do you deal with the systemic nature of this? That is what law is struggling with. That is what all of us are struggling with. We can't give it such a low threshold, but we also realize that if it weren't for that first dog whistle or that first hateful dialogue, this whole narrative structure would not exist. There's a professor of law called Charles Lawrence, and he said that anything that has the potential of causing a democratic process deficit is hate crime or hate speech. And I saw that democratic deficit happen after FIR 59 of 2020, which was the primary FIR. If you look at the wordings of that FIR, it talks, and the prosecution case thereafter, it says Umar Khalid gave Muslims an articulation of their grievances and a methodology to articulate them. So what you're throwing at Muslims is that you don't have the right to mobilize, and you don't have the right to articulate your grievances, even if they're made up grievances, right? That shouldn't be a concern. That, to me, was an explicit reduction of our democratic space that caused a democratic deficit. But because it's framed in a way that anything that the Muslims do publicly, politically, is now almost a terrorist offense, it's taking away space from us. It's taking political space away from us. That is a definition of hate crime. That is a definition of hate speech. And it's very ironical that it is being done to us through law that actually governs speech. Again, European jurisprudence says that these are things that should be monitored very closely. So when you feel that a community is being targeted, and when you feel that a community does not even have the space to articulate, to contest what is being done to it, then it calls for heightened judicial scrutiny. The courts have more of a duty to scrutinize each time what is going on and to intervene. But when that moment passes, then you can relax a bit. Then that's not the time for heightened judicial scrutiny. Then you let them contest in other spaces, in political spaces, cultural spaces, and law can take a back seat. But law needs to be very, very careful and very alert all the time. It should sit up every time there is a problem. So the only problem then to deal with, with those dialogues is to not regulate it, not ask for its criminalization, because that's absurd, it can't be. But to have counter articulations ready in the cultural space, in the academic space, in all kinds of spaces, and to ask for compensation, because the threshold for civil rights is always much, much lower than it is for criminal rights.